Good morning. It's time to start, and we've got a quorum already. So we have two papers to be discussed today. So we've got paper ECI 2012-2013 number 6. This is an information paper on the latest position with regard to the directorate establishment. The paper also contains information about directorate posts to be created and deleted within the 2012-2013 legislative session. And the administration has also provided us with information paper number ECI 2012-2013 number 7. This paper outlines changes in the directorate establishment since 2002, and the paper also contains information about the implications of the two discussion items on the directorate establishment. May I remind members that if you have direct or indirect pecuniary interests in relation to the items discussed today, please disclose the nature of the interest before you speak. And this is in accordance with Section 83A of the Rules of Procedure. And may I also remind members that under Section 84 of the Rules of Procedure, there are certain requirements with regard to voting on the part of members with direct pecuniary interests. So we have item EC 2012-2013 number 9. A proposal to create a supernumerary directorate post in the operations department of the ICAC for a period of 30 months from 12 December 2012 to 11 June 2015. And concerning this post, the salary is IPS 46. On the 6th of November, the security panel of the LegCo was consulted. The chairman of the security panel is not here today, and so I will give members a brief report on his behalf. On the 6th of November 2012, the security panel discussed their proposal. Members basically felt that there was a need to provide reasonable support for the ICAC to do its work so as to uphold the reputation of Hong Kong as a clean city. At the meeting, some members said that prosecution action has already been taken against certain persons by the ICAC, but then they asked why there was a need to have a supernumerary post lasting for 30 months. According to the ICAC, the case was extremely complex and huge volumes of documents were involved and evidence gathering was still in progress, and so there was a need to have the post lasting for 30 months to continue to deal with the complex case and to prepare for the court proceedings. So the panel in principle supported the submission of the item to the ESC for its consideration. And perhaps we can have an introduction to the paper by the ICAC. And to answer members' questions, we have Mr. Simon Pei, Commissioner ICAC, Mr. Ryan Wong, Head of Operations ICAC, Mr. Ricky Yao, Director of Investigation, Private Sector, and Mrs. Jenny Au-Yeung, Assistant Director, Administration ICAC. Yes, Commissioner, Chairman, we're here today to seek members' support report to apply to the FC to create a supernumerary directorate post for a period of 30 months. On the 6th of November, we consulted the security panel and we got the panel's support. Now, concerning this officer, he will lead 16 non-directorate officers. He will head the special duty group to follow up on a case which is extremely sensitive and complex, and the scope is extensive, and also the matters involved are oblique and subtle, and those involved include the highest level in a listed company as well as a very, very high-ranking former government official. And so there is a need for this supernumerary post. There is a need to have a special duty group to take charge of the investigation. Now, the candidate will lead the special duty group. He will also provide professional support for the lawyers team, and he also has to attend conferences with the Director of Public Prosecutions and Counsel in the prosecution team, both locally and overseas, on pretrial preparations. And the work is extremely sensitive and complex, and so this supernumerary post must be filled by an AD with a lot of management and investigation experience. Now, we have a case law of 2,258, up 9% when compared with the figure for the same period last year. So in fact, our manpower resources are very stretched. The different teams in the operations department have a lot of work to do, and so we really can't have the work absorbed by the teams. And also AD3 and AD4 also have a very heavy workload, and it is not possible to expect them to steer the work of the special duty group as well. If they are asked to do so, that will affect the effectiveness and efficiency of the work of the special duty group. In June this year, we created a short-term supernumerary directorate post, and we also, through internal redeployment of resources, set up the special duty group. Now, without LegCo's approval, we can only create a supernumerary directorate post lasting for 6 months, and that's why as this post will lapse in December of this year, we need to apply to LegCo for approval. It's true that prosecution action has been taken and in fact the case will will be adjourned to 25th January next year for mention. But then there is still a lot of work to do, and so we feel that we need the posts for 30 months till June 2015. So these are my opening remarks, and I am willing to answer members' questions. 4 members have indicated that they would like to ask questions. So 5 minutes for each member. Mr. Kenneth Leung. Chairman, I need to declare interest. I work under a law firm, and 2 of its partners will be representing the directors of the listed company concerned, but I am not directly involved in this case. So I would like to ask this question concerning this supernumerary post. I would like to ask whether ICAC previously had to create a supernumerary post at AD level for another case in the past, a case similar to this one. And then second, now at the moment, there we have an officer acting in this post already. So if this proposal is approved, will there be a process to select the best candidate for the post? When the 6-month supernumerary post lapses, will you have this so-called internal recruitment to fill this post? But Mr. Leung, this is going to be a 30-month post, not 6 months. But then now at the moment there is someone acting in the post. This present post will last for 6 months. There was no need to come to Finance Committee for approval. But then when the 30-month post begins, and before that, will you do a selections exercise all over again to select the best person for the post? Commissioner, Chairman, to answer the first question, there was a precedent. In the Carrion case, some supernumerary directorate posts were created to handle the case. I beg your pardon. The stocks exchange case, a supernumerary post of AD was created to deal with the case. And then in June, we created the short-term supernumerary post. And at that time, we did go through a selection process and mechanism, and we selected a colleague to fill the post. The colleague, in fact, was promoted to AD level at the end of September. And so, if LegCo gives a green light with regard to this 30-month supernumerary post, this colleague will continue to be in this post. Now, I think you appreciate the need for continuity in dealing with this case, and also given the complex and sensitive nature of the case, it is not appropriate to have another colleague heading the special duty group. So what's going to happen to this post after 30 months? So one colleague was promoted to AD level, so that is his permanent rank, so to speak. But then what if 30 months later there's no longer a need for this post? So how are you going to deal with this colleague? Commissioner, 30 months later, if we no longer need this post, then the post will automatically lapse. But then if there is a need for us to still have that post, then we will come back to LegCo to seek an extension. Now, the colleague was promoted to AD in September. And concerning his AD post, we have an acting officer acting in that position. But of course, if we have an AD vacancy, this officer can continue to act in the position and can maybe promoted. Otherwise, he will still be in an acting position. Ms. Emily Lau, on the 6th of November, at the security panel, members gave a lot of comments. Now, after the meeting, some members of the public told me that they were worried that FC might not approve the post. So, members of the public are of the view that this is a battle against Raphael Hui and against the Kwok family, and they think this is really a very difficult battle. And you know, many prominent lawyers have been hired by them to represent them, and the public are worried that we may not have enough resources, we may not have enough ammunition or weapons to fight this battle. Now, you know, they have already hired a lot of accountants, lawyers to represent them. They will also be getting lawyers from overseas. So, how does our team compare with their team? That's our concern. And then second, concerning the establishment of the ICAC. Now, of course, I'm not going into details today. They say that there was one director who retired, and then another person who had retired returned to the ICAC. So it seems that you do not have enough talents, so to speak. So is it that every time you have a vacancy, you have to get someone who has retired from the ICAC back to fill that post, at least for the time being? Of course, I understand it's not your problem, and it's not your responsibility. I mean, this poor succession situation. But then, perhaps Commissioner, you can tell us whether it's very difficult to find suitable people. And then, Chairman, this post is specifically for this case. And Chairman, may I refer to enclosure 3? We can see that there are 4 ADs. And according to the Commissioner, the 4 ACs can't take up the work of the special duties team or the special duty group. But then you can see that there are these 4 ACs, and each of them takes up a lot of duties. But then concerning this proposed AD, he will just be responsible for one case. Is that really necessary? Is it that previously there were precedents when one AD only took care of one case and there was no need for him to take care of other business?
Let me answer the first 2 questions, and then I'll defer to Mr. Wong to answer the rest. First of all, regarding whether we have sufficient resources, whether it's the ICAC or our Director of Prosecution, we have many years of experience to deal with different cases. I believe we have sufficient ability and experience and the expertise to deal with this case. And secondly, regarding the question of candidates, the proposed supernumerary AD post, this will be taken by a colleague who had just been promoted this year, and his original AD post will be taken up by another colleague so we're not going to hire someone from outside. Because some people may feel that we might have a problem regarding succession within the ICAC. Overall speaking, I don't think we have any such problems internally, except that earlier the post of the Director of Operation did encounter some problems regarding succession. As for the other ranks and posts, I don't think there are any problems. So I think members can rest assured. I'll defer to Mr. Wong to answer the 3rd question. Mr. Wong. Thank you. Over the years, the Operation Department have been dealing with major cases, and it's not true that each and every time we would ask an AD to take up the case. It would depend on the nature of the case. Take the Carrion case or the Overseas Trust Bank and other major cases. It was necessary to have an AD to steer the investigations. For the SHK, LegCo at the time, we did apply to LegCo to create an AD, a supernumerary post to deal with the case relating to the stock exchange. For the present case, like Mr. Pak said, indeed it is a very complex case and involving many people. Given the nature of this case, we believe that there is a need to create an AD post to take charge of this the case. The 4 ADs at the moment have their respective responsibilities. We've given it due consideration, and we think that it's not possible for any one of these ADs to take charge of this particular case. Mr. Poon Siu Ping, thank you. In principle, I support the proposal to create an AD post to deal with this important case. But I also like to seek clarification regarding a few points. In para 9, we understand that the special duty post will have the support of 16 staff. In para 5, you say that 15 of these staff has been set up through internal redeployment. You told us that your caseload has gone up by 9% compared with last year. So how has the work of the other divisions been affected because of the redeployment? For the 15 staff redeployed, will you be recruiting new staff to take up their positions? Commissioner, thank you. Over the last 6 months, we had created 16 temporary posts because we're not able to recruit, and that's why we're able to achieve the purpose through internal deployment. Obviously, this has added to the workload of our existing departments, so we can only ask our colleagues to do the work overtime to make up for the shortfall. I don't think this is healthy in the long term. So this time, if we have the approval to create this supernumerary post for 30 months, we will proceed to recruit staff, and after we've recruited new staff, we'll be able to reduce the workload so that our existing colleagues will not have to do so much overtime work. Chairman, Mr. Poon. So for the short term, you are relying on your existing colleagues to work overtime, but in future you will need to create additional posts. When we have formal approval to create these posts for a period of 30 months, we will proceed to initiate recruitment. Dr. Kokka K. Chairman, the Civic Party fully agrees that there is a need to maintain Hong Kong's image as a clean city, and we also support the proposed creation of this post. What I'd like to know is that, as the director said, this is a very unique case. So how much opportunities will there be? Are there going to be any other such special cases? Last year, there were many complaints about corruption involving not only the CS, the former CE, according to some press report, has a possibility, has a chance he might be subject to investigation. So will the ICAC will have to create another post to investigate into the CE and other senior officials? Is it the case that each and every time they will have to apply to the FC for the creation of additional post? I think we need to be cautious in doing so, but I would support that if there is sufficient ground to hire additional staff. Secondly, this is a very complex case, and I wonder whether 30 months are sufficient. For the carrying case, I think the investigation went on for many years. Why is the ICAC so confident that within 30 months you'll be able to conclude the case? Even before the trial starts, are you already preparing to put an end to your work after 30 months? And thirdly, regarding, you now have 2,250 cases under investigation, and it's more than 9% compared with last year, of which 413 are election-related cases. Does it mean that the rest of the cases, other than those election cases, how do they compare with the figures in previous years? Have we seen a major upsurge? And finally, I'd like to refer to the enclosure. That is, I note that from 2010 up to now, the number of directorate posts has gone up from 14 to 17 plus 1. For B and C, that is those at MPS 0.33 or equivalent, there has not been any increase. Are you favoring the senior echelon at the expense of those who are low in ranks? You've increased the establishment at the senior level from 14 to 18, almost 20% increase. Do you have sufficient manpower, below the directorate level, so that you will be able to tackle corruption effectively? Chairman, I think Dr. Koch. has already, as Dr. Kwok said, we're not able to comment on individual cases. So I will not comment on any individual case. Of course, what's going to happen, nobody knows. If indeed there is going to be a major case going forward, we will certainly assess our manpower situation at the time. Of course, we will not rule out the possibility that should there be a major case, we might need to come back to LegCo again to apply for the creation of other supernumerary posts. I can't rule out that possibility, but I won't say that this would definitely happen. As it stands now, that's all I can say. As whether or not 13 months are sufficient, I would like to invite Mr. Wong to further elaborate. Mr. Wong. Thank you. We are applying for the creation of this post for 30 months, and this is based on our experience in dealing with major cases in the past and the workload arising from this case. Investigation is still ongoing and the workload is very heavy. The case has now been referred to the court, and later on there will be a trial. The pre-trial work we believe will be very complex and enormous. We've made the 13-month estimate and it's based on the schedule of the court and also the nature of the case. Obviously, if the case develops in such a manner that it's concluded before 30 months, we will certainly terminate the supernumerary post. But if 30 months are not enough, we will come back to LegCo to apply for an extension. There's one more question I haven't answered yet. Dr. Kwok said that we have a 9% increase in our caseload. That actually includes the 413 related cases. If we leave those election-related cases alone, then our figures have dropped slightly. So members, please remember that there is a 5-minute rule. Finally, the last question is about the number of the directorate posts. Why has it gone up to 14 to 17? I think members recall that earlier we had applied to LegCo to create a 3D1 post earlier. Mr. Chung Kwok Pan, Chairman. I'd like to follow up on the proposal to create this post for 30 months. I understand that the Department of Justice will also create a Chief Government Counsel post. We heard that the case is very complex, but the DFJ will need to create that post for 5 years. That is the post of Deputy Principal Government Counsel to follow up on this case, while the ICAC only requires 30 months. Does it mean that the workload for the ICAC will be quite heavy originally, and then the workload will gradually go down, and therefore we do not need to require the same timetable as the DFJ? Mr. Wong. We are applying for a 30-month supernumerary post. We are focusing on the work of the Operations Department. We are responsible for investigation, the pre-trial preparation, and assisting the prosecutor with the prosecution. What happens afterwards, for example, appeals, would not fall within the remit of the ICAC. As far as appeals are concerned, the workload of the ICAC will be much less compared with the pre-trial work. So we therefore believe that the 30-month period it's appropriate, and that's why it's shorter than that required by the DFJ. Of course, you need to create the post when there is such a demand. We all know that this is a complex case, and is expected to be protected. And we read from the media that the defendants have now already engaged very senior counsels for the defense, and I don't think the case will be concluded within the next 2 to 3 years. So why don't you ask for a longer period like the DFJ instead of having to come back to us again for an extension later? Thank you for Mr. Poon for your question. If there's a practical need for us to require 30 months, we will do that. I've already explained to members that if the workload at the time require us to continue with this post, we will continue to come back. We will consider coming back to Electrical for an extension. Mr. Martin Liu, Chairman, I was late, so I don't know whether or not this question has been asked. I would like to ask a question relating to the DFJ's application. But I would also like to take this opportunity to say that I support the ICAC's proposal to create the supernumerary post. I've read the paper and I accept the professional opinion of the ICAC. That is, the case is very complex and they need to beef up their manpower in order to deal with this case.
Second round, Ms. Emily Lau. Now, the DP, of course, supports the work of the ICAC. Now, the ICAC is very important to Hong Kong, and so please work out better succession arrangements. According to the Commissioner, there are some succession plans in place, but then concerning the Director of Operations or Head of Operations, that there are some difficulties. So may I now, Chairman, ask a question with regard to Para 4. We've seen more complaints, and then including 413 election cases. So is it that you don't have enough people to do the work? It seems that concerning election cases, the progress of your work has been rather slow. And I think you really need to go back to the complainant in black and white. So we are worried that you are dragging your feet with regard to the handling of election cases because you have other work to do. And then concerning people having to work overtime because you can't carry out open recruitment. So I just want to know when you can start open recruitment, because if there aren't enough people to do the work, that will affect the efficiency of the ICAC. I'll answer the second question, Chairman, and then Mr. Wong will take the first one. In fact, we are now having our recruitment work underway. We have some vacancies, and we expect to have some new posts, new vacancies, and so we hope that we'll have new recruits joining us early next year to receive training, and that would help to reduce the need for overtime work on the part of our staff. Mr. Wong. Chairman, with regard to the investigation of the 413 election cases, they are taken up by Group X. And there are about 40 to 50 officers in this group. Officers in this group have accumulated a lot of experience in investigating election-related cases. And of course, we, in the light of our experience, also review our investigation approach so that we can make even better use of our resources. Now, concerning individual cases, now Ms. Lau, if you are interested in a particular case, you can contact me and I will try to give you more detailed explanation. I just want to say that we do review our investigation tactics and strategies from time to time in order to make the best use of our resources. But of course, if we really feel that we do not have enough resources to do our investigation work, we'll see what we can do to make sure that the progress of investigation will not be affected because of insufficient resources. Now, what I'm trying to say, Chairman, is that after people have complained to you, you should give replies to the complainants in black and white. Do you know that in Geneva, someone snatched my handbag, and the reporting procedure was brief and simple, and then a few days later, I was given a very detailed reply, a few pages. So I want to know why there has been such delay. Is it because of the electoral election? The 413 related to the electoral election, including other elections as well. So so there has been delay for years. No, not years, Chairman. The DC Council, this DC election took place last year, the LC election this year. And also, I want to say that we need to investigate into election expenses, and when REO referred such cases to us, there would be a time gap. Usually, it was or it would be some months later. Mrs. Regina Ip, our party supports the creation of the two posts, Chairman. Yes, I understand that they need extra manpower resources. Now, I think, say if we have a renowned family wanting to take part in a court case, people will say you should try to approach a larger firm, because even if you hire two senior counsels, you need a lot of support for these two senior counsels. So is it that for the D.J. post, it's mainly to support the counsels? Is it that they you have to do a lot of work, search a lot of documents, do a lot of research? But Mrs. Yip, sorry, we are on item 1 only. But we're talking about the same case. Why aren't the two items dealt with together? We deal with them separately. These are two separate posts, and also the time, the duration of the two posts is also different. But all right, Chairman. But I want to say that in principle, our party supports the creation of both posts. Both. Mr. K.K. Kwok? Yes, Chairman. I want to ask about the long time taken for investigation work. Now, of course, we agree that ICAC should investigate all complaints thoroughly. But then you're going to have to deploy people to the special duty group. So does it mean that your manpower situation is further stretched? And have you experienced delays because of shortage of manpower? And then second, it is said that the morale in the ICAC is not high, and some are worried that the wastage rate is very high. Is that the case? And then para 12 says that AD3 is responsible for G group. In other words, the Interception of Communications and Surveillance Ordinance. In fact, the chairman of the commission, the Commissioner for Interception of Communications and Surveillance, has complained many times about non-compliance on the part of LEAs. So in the ICAC, is it that because of shortage of manpower, you're not able to achieve a compliance level specified in the ordinance. Now, because we do expect all LEAs to comply with the law, you enforce the law, so you must first comply with the law. Who can give an answer, Commissioner or Mr. Wong? I'll answer the second question. Mr. Wong will take the first and the third questions. Concerning the morale in the ICAC and the wastage rate, I want to say that there is no morale problem in the ICAC. In fact, the morale of our colleagues is extremely high. Second, the wastage situation has improved. The wastage situation is not as serious as that before. But of course, there are many reasons for staff wastage. In fact, during a certain period, a lot of our staff went to join the private sector. But then I want to say that the situation improved greatly over the past 2 to 3 years. What about the wastage rate? Do you have figures to show that there has been significant improvements? There has been a significant improvement. Do you have some figures, please, Commissioner?
就或者我手頭上嘅資料呢。
Now, for example, the entry grade assistant officers. In 2008, non-natural wastage, we lost 34 people. This year, we expect the number to total 17. So the number will be halved. So that's just an example for members' reference. What about the third question, Mr. Wong? Chairman, thank you. Now, we have about 40 to 50 officers in each team. But of course, if we have more cases and fewer people, then of course, the progress will be affected. Delays may be inevitable. But then, within the ICAC, we have a monitoring mechanism to make sure that there won't be too much delay. Now, for example, in the operations department, we have the operations review committee meeting every 6 weeks. And if the investigation of a particular case exceeds 12 months, or if a person is arrested and is on bail for 6 months, then the in charge of the team has to give an explanation to the ORC. And so this is an effective mechanism which has been serving us well. And then the wastage situation. Now, as the Commissioner has pointed out, open recruitment is underway, and we hope that we can find suitable people to join the ICAC. But then it doesn't mean that having new recruits will solve all our problems, because it takes some time to train these officers to carry out their duties effectively. But of course, we hope that we can retain our trained, experienced colleagues. We hope that they can continue to serve in the ICAC so that the quality of our investigation work will not suffer. And then interception of communication and surveillance. I want to say that this ordinance has affected our work, no doubt. Now, that is a relatively new piece of legislation, but that it provides a clear legal basis for us to carry out such duties. Now, when the ordinance was passed, and when we started acting in accordance with the ordinance, now of course at that time there were problems. We didn't have the necessary experience. But then after errors have been made, we put in place mechanisms to make sure that such errors will not be repeated. So 5 years have lapsed, and I think our operations people have already grasped the basis for carrying out such covert operations. Now, if members have no further questions, I will now put this item to the vote. Those in favor, please raise their hands. Those against? I think members who have taken part in the voting support. In fact, all of them support the proposal. So the proposal is approved. And we move on to the next item, EC 2012-2013/10. So this is a proposal to create a supernumerary post of Deputy Principal Government Counsel, pitched at DL2 from 18th December 2012 to 30th of September 2017 to deal with a major and serious corruption case. The AJLS panel was consulted on the 30th of October. It was a special meeting of the AJLS panel. And we have with us Mr. Arthur Ho, Director of Administration and Development, Department of Justice, and Mr. Kevin Servos, Director of Public Prosecutions, Department of Justice. The chairman of the AJLS panel, Ms. Priscilla Leung, is not a member of the ESC, and she's not present at this meeting, and so I will briefly report on the deliberations of the panel based on the note prepared by the Secretariat. At a special meeting on the 30th of October, the panel discussed the proposal to create a supernumerary post of Deputy Principal Government Counsel in the Prosecutions Division of the DOJ. Now, some members expressed concerns as to whether there was a need to create a dedicated post lasting for 5 years to deal with one specific case. This is and it was a supernumerary post at the L2 level. Members also asked whether there had been precedents, and some members asked what would happen if the trial time was less than the anticipated 5 years. And some members were of the view that as there was a DL1 officer acting in the post to manage the case, they doubted whether there was a need to create a supernumerary post at a higher level. But then members of the panel did not object to the submission of the proposal to the ESC.
And I invite the DFJ to make any supplement information if they have.
It's my request today of you to seek endorsement for the post of a Directorate Level 2 position in relation to this case. I won't go over the particulars of the case. The material speaks for itself, and there's already been a discussion with the ICAC's request for the position. But I would like to just add some comments in relation to the concerns that have previously been expressed, and maybe in an endeavour to try and alleviate those concerns that may be with the members today. Firstly, there is a need for the post. There's a need in order to deal with this case in a fair and proper manner. That's my objective in relation to any prosecution, to ensure that it's prosecuted fairly and properly. And it's important that we put our best foot forward, that we do our best in the presentation and preparation of this case. And so therefore it needs to have, firstly, from my assessment of the situation, and that's from a background of having been involved in prosecuting and dealing with white-collar crime cases for nearly on 30 years, that we need to have somebody at the level of a Directorate Level 2 to take on the responsibility and oversee the work that needs to be done in the background as part of the preparation, and also dealing with the ongoing issues and aspects that will arise in the course of this case, which is clear is going to be one that is complicated and is going to be difficult, and it's also going to be strenuously contested. So that's quite apparent. So there is definitely a need to have, in my professional assessment, a specialist team to deal with this within the DOJ, and we need this additional post. In relation to the fact that currently a person who is a Directorate Level 1 is fulfilling that responsibility, I mean, that really is just the fact that that person is actually undertaking Directorate Level 2 responsibilities, and they're acting up with regard to that position. But it does indicate, although there's not much of a difference between a Directorate 1 and 2, except for the added responsibilities and the need to be dedicated to this particular task. And obviously we're seeking to have somebody that's going to be there for a significant period of time. We're looking at 5 years on an assessment of the case. Now, in relation to the current position, the person who's occupying that position is doing that on an acting basis and up until December. That's why we're here today. We're seeking to have a position on a supernumerary post from December 2012 to September 2017.
Okay.
Thank you. We have 5 members who would like to speak. Shall we stick to the 5-minute rule? Mrs. Regina Yip. Thank you, Chairman. Just now the Commissioner already told us that there is a need to create a supernumerary post to ensure that the prosecution is fair and proper. And I think we all support that principle. But specifically, what I'd like to know is what sort of support work is required. Would it be the same as that of a solicitor's firm supporting the counsel, that is helping the counsel to look up information and discover documents and so on? And secondly, originally I had a question as to whether or not, I think you really answered the question that it's going to be, you're going to find an internal candidate. This person is a DL1 and he's been acting the post, and you're just promoting this person. As a former civil servant, I support that. My question is, what happens after 5 years? Are you assuming that this DL1 post will stay on at the DL2 post? There's no reason to degrade him, to downgrade him to DL1 after 5 years.
Mean that the particular person, as an example, isn't going to be considered for promotion in relation to other substantive positions that may come up at the DL2 level. So that person currently, who is a DL1, will obviously be considered for other promotion exercises in relation to other available positions. But it clearly means that whoever is going to occupy this position for that period of time, once it comes to an end, their occupancy of that position comes to an end as well. And so they go back to wherever they may be at the time. It could be that that person's promoted by then to a D2. It could be that they're not, and they go back to a D1. That's the way it works.
What about the answer to my first question? Will this officer be functioning like a supporting solicitor in a large law firm when there's a major prosecution going on?
Yes, I mean, this person's going to be carrying out an array of duties. You can imagine a case of this type, and you can imagine any form of very heavily fought or complicated litigation requires a whole array of matters and issues. And not only that, is not only have to deal with the case itself, in dealing with the correspondence from the parties, dealing with the preparation of the case for trial, researching law, dealing with a whole array of issues in relation to follow-up of inquiries, etc. But you've also got to deal with the administrative aspect as well. That person is a public servant, a government counsel. So not only have they got responsibilities in relation to the dealing of the case itself proper and dealing with it from an outside point of view, but also internally in terms of making requisitions for additional funding or for requisition for assistance or resources, dealing with securing expert evidence or making the payment of counsel's fees. A whole array of matters. I could go on and on and on, but it's a tough job and there's a lot to it.
Okay. Thank you. Mr. Martin Liu. Thank you. Basically, I support the proposal to set up a dedicated team to deal with the prosecution relating to this complex case, and there is a need, obviously a need to have a senior, staff to take charge of this team. I respect the professional judgment of the DFJ. That is, you need a dedicated person to take charge of this case. We've heard that the defense will be setting up a very strong legal team. But I believe, having read the papers myself, I believe that the DFJ will also be engaging QC from the UK and many senior counsels in Hong Kong to help with the prosecution work. So I don't understand why a Deputy Principal Government Counsel and why do we need to upgrade the post? Because Mrs. Regina Yip also said that the incumbent of this post will basically be providing backup support. If I look at the terms of reference of the Deputy Principal Government Counsel, there are 7. Other than points number 1 and 4, the rest are only support, coordination work, ensure operations will run smoothly, and also handling inquiries. So 1 and 4, it's about handling of evidence and providing legal advice to the prosecution department. For 1 and 4, you already have senior counsels and QCs from the UK and locally. And these are the work to be done by the so-called star-studded team. That's bullet point 1 and 4. So I don't understand why the deputy post, why an assistant post, why is it that the Deputy Principal Government Counsel post is so important?
There's clearly a difference in terms of responsibility and work between the counsel, the barristers, as you would appreciate, that are going to conduct the case in court, and those that are working behind the scenes, preparing it and dealing with the other parties. We have 5 parties here, all separately represented. There's a multiplicity of representation. There's more than one firm sometimes with a particular party that we have to deal with. So you need somebody of the appropriate status and responsibility to be able to handle this sort of case, given the nature of it and given the likely issues that are going to come up, and the need for somebody that's going to be responsible and take on the responsibilities that are going to be required for them to do so in order to fill their functions. Basically working, as Ms. Ip has correctly sort of identified, as a solicitor, providing solicitorial function, so that person needs to have the status and responsibility of a D2 officer, because you're going to be dealing with senior partners of firms, you're going to be dealing with counsel of the highest calibre, So we really need to have an appropriate level of responsibility in relation to the position. Now, you may make the point to me and say, well, currently that's being handled by a D1 officer, but we'll be expecting that D1 officer, or whoever it may be, to rise to the occasion to fulfil a particular standard and set of responsibilities that we would expect of a D2 officer. It's that sort of case, and it warrants that sort of responsibility. I want to be able to put my best foot forward in prosecuting this case, and I don't want to do it with one hand tied behind my back. So it's important that we give this position its appropriate accreditation as a D2 position, which it deserves in these circumstances.
好，你有跟進啊？嗱，時間好緊啊。
Saying to me is that this is purely an enhancement of status for the officer because we're always talking about the same officer doing the same job.
No,
and then you have to raise the status in order to sort of facilitate his or her work.
It's a reflection. It's a reflection of the work that person is expected to do. It's not an improvement of that officer's position. It's an expectation of what we expect of that officer in terms of the particular job that I anticipate that she will need to perform. So she has to rise to the occasion. We're not dropping down to her level. She has to rise, and whoever else that fulfills that position, it may not be her once this position is offered. But it's to fulfil those responsibilities and duties as we set out in the statement there attached to the paper. Thank you.
何生有少少補充啊。
我想補充一點咧，就係其實我
Mr. Ho, we're creating this post. First of all, we've looked at the nature and the importance of this post. We have not looked at which candidate should take up this post. First of all, we considered the complexity of this case. And when dealing with such major cases, normally we would have a Deputy Principal Government Counsel to deal with such cases. Since work has to start, and therefore we need to proceed on an interim basis. So we will look at the experience and ability of the colleague and whether or not her track record is suitable, and therefore we've identified a colleague who previously was a Deputy Principal Government Counsel. I think this is a common practice. That is, we will look at the nature and the complexity of the work to determine what grade of what is the grade of the officer required to handle the case. Mr. Kenneth Leung, I'd like to declare once again that the solicitor I work for, there are two partners who are instructing solicitors for the one of the parties in this case, but I'm not directly involved. My question is that you assume that the post will be created for 16 months. The ICAC would require 30. Are you assuming that the case, the trial, will go all the way back to the CFA? In that case, would 60 months be sufficient? So what is the basis of assumption that you need 60 months? And secondly, to follow up on Mr. Liao's question, in para 8, regarding the interim staffing arrangements, you say that you will recruit local senior counsels and QCs from abroad. For the interim staffing arrangements, for the local SC and the overseas SC and so on, what is the ratio between the local SC and the overseas QC? And you say there will be several junior counsel. I'd like to ask whether you will be recruiting these junior counsel from abroad or will they be recruited locally for the entire team. The QCs and junior counsels from overseas, how many will there be in total?
That's an estimate from our experience in terms of cases of this type, the likelihood of when it's going to come on, its duration, then the appeal processes. So we're looking at that period of time. We think that would be about right in terms of this case going from birth to grave. It may be it's longer, it may be it's shorter, whatever. But I can't say. But it should be around about that sort of period that we'd be looking at from experience. So that explains the duration. We're taking into account also possible appeal processes being employed subsequent to the case. That's quite obvious. In relation to the recruitment of counsel involved in the case, that's a fluid situation to some extent at the moment. We've got to deal with the situation that we're confronted with. The defence so far have employed and approached a numerous number of counsel, and already there's been a multiplicity of counsel involved on behalf of the defence, and they change. In relation to what our particular needs are, well, we'll obviously need a team here, and we'll probably need a team that will assist the overseas counsel. I'm keeping the situation fairly fluid because it's a question of what's necessary and appropriate. And it may change because it depends on the teams of counsel that will be employed by the defence. So far, the indications are that there are 5 defendants and there are 5 separate legal teams, and they are heavily represented by an array of senior counsel as well as junior counsel. So we have to be able to deal with that, and it means that if necessary we will employ the appropriate number of counsel to be able to handle the situation that we're in. So it's contextual. And at the moment we have a team of counsel, local as well as overseas, that are working on the case. As to whether we may need to expand that will depend on the circumstances that we're in. I can't give you a better answer than that because, again, I should be enabled to deal with this case in a manner that ensures that it's going to be properly prepared and presented. And I should be also in a position where, according to my professional judgment and those of us and those that assist me, that we make sure that the case has the appropriate resources to not only present the case but also to deal with the defence case that may be mounted. So that's important, and I think those that may have some experience or knowledge in relation to criminal trials would appreciate that you have to make sure that you have the best team and that you have a good team that's going to deal with the array of issues and matters that are likely to come up and that will come up.
主席，我有第二輪問題一間嚇。
I'll queue up again, Chairman. Mr. K.K. Kwok. Chairman, the Civic Party supports the creation of this post. But I want to know more about this proposal. Now, it is said in the paper that this is a corruption case of unprecedented scale, and so they are asking for a supernumerary post. This we can understand. Now, in the paper, it is said that this Deputy Principal Government Counsel doesn't merely provide support. He also plays a leading and steering role in the team. So, of course, we want to have the best person for the job. Now, we have no objection to creating this post. But then, now, at the moment, we have someone acting in this position. We have someone acting in this post. But as I think we all know that on the defense side, they have a lot of senior counsels. They have a very, very strong team. And so, do you think this person is experienced and competent enough to deal with this case, given the so many senior counsels on the other side? And then second, of course, we don't know what the legal cost will ultimately be. But then you may need to hire senior counsels, QCs, and of course, you have to incur costs as a result. So, what is your assessment of the cost? In other words, what I mean is, do you need to have a more senior person with more experience in this post? That's my worry. And then now, of course, apart from this supernumerary post, there are other lawyers in the DOJ to deal with this case. And will this have an impact on the progress of other cases handled by the DOJ? For example, will there be more delay with regard to the taking of prosecution action because some staff resources have been deployed to deal with this case? Because some people say that there has been some delay concerning the taking of prosecution action and the case going for mention. So who can answer this question, please?
Firstly, this person wouldn't be in the position right now and acting in it unless they had the experience and had my confidence to be able to handle the responsibility. The current person that's acting is a person that's been with the department for over 16 years, and I've worked with closely in a lot of major cases. As you may appreciate, I am a specialist in white-collar crime myself, and I've been fighting white-collar crime cases and corruption cases for the 20 years that I've been here. And before that, I was in charge of major fraud with the Federal Director of Public Prosecutions Office in Australia. So I come from a pedigree and a background of being familiar in this sort of work, and I know who's talented and who's able to do it. And the current person who's acting in the position is a very able and capable person who's worked in this area, and you can see from their background, to be able to handle this sort of responsibility. That's not saying that there aren't other people as well in the organisation, and they'll have to be considered as well. You commented that on the second aspect, and so I have confidence that we have the experience. I mean, we've been doing this sort of work for many, many years. We have a specialist commercial crime unit. Our people are put into specialist units to do this sort of work. Corruption, we have specialist units to do with this sort of crime. So they've got the expertise. So we have people that we can call upon to deal with it, and to deal with it at this particular level and level of responsibility. The question that you've also asked is whether or not this is going to fulfil the sort of work and the responsibility that will be expected of them. I believe so. I believe a D2 officer should be sufficient in order to deal with this. Remember, they're going to be part of a team, and that they're also going to be working with very experienced counsel that we're going to be bringing in as well. So there's going to be a role and responsibility, and this all has been worked out through our past practices. We understand how to do this. We understand how to work with each other, and we have a demarcation of responsibilities and duties and tasks. And finally, in relation to the impact on other cases, I'm surprised to hear your remarks, because we've been doing very, very well. I mean, my counsel are working day and night. They're a young breed of people, but they are the future generation of the rule of law of Hong Kong, and I'm very confident, and they work very, very hard, and I stand by each and every one of them in the work that they do.
My question is that whether we object the ideas of creating this post. My question is whether we need to a more senior post in relation to that. And regarding the last point you mentioned about the, we understand that all the council, the young and brilliant council, work day and night. That is an issue that we are worrying about, whether the shortage of the manpower will jeopardize the pace, or at least the successful ways of whether we can proceed on prosecution of many cases. Will there be any implication of more manpower or maybe resources being allocated to your department?
Well, I've carefully considered this. That's why we're here today. We've asked for this additional position. I mean, we're always constantly recruiting and bringing in new people into the organisation. And, it will mean that I'll have to move somebody to take over the responsibility. But we've calibrated it, and we've looked at it. I mean, my overall responsibility is to make sure that the office overall works and works effectively and efficiently. So I'm making sure that it will have minimal, if any, impact on the rest of the office. Although I should say we have extraordinarily heavy workload generally. That's why we need this specialist team and post. And so we have to deal with that. That's a separate issue. But we're very conscious of it. I understand where you're coming from and the concerns that you're expressing, but we are addressing it. We're making sure it won't have any adverse or deleterious impact on the rest of the office.
Okay.
Ms. Emily Lau. Thank you. Chairman, now this post will be for 5 years because there may be appeals. Now, yesterday, Chairman, we had the appeal, we had the judgment delivered by the CFA on the citizen radio. And that case lasted for 4 years, from 2008 to 2012, more than 4 years. This case, this one here in the paper, is even more complex. So in our case, citizen radio took 4 years. And this one in the paper is even more complicated. Now the DP supports what you do, but then do you think 5 years is a realistic or accurate estimate? Now, of course, the DP and members of the public support the fight against corruption. And if some people are arrested, prosecution action should be taken in a fair and effective manner. Yes, we understand that the defendants have a very huge and a high-quality team, and some members of the public are worried that the administration's team may not be as strong. The administration's team may not be strong enough. But then, concerning our case, yesterday, the CFA's case, it took 4 years. And it was only, I think, a rather minor case. We just said something on the street. And then we are told that for this post, it costs 2.63 million per year, including everything, benefits. But then it said that you also hire QCs, SCs, and what is your estimate concerning the cost? Hiring overseas QCs, ICs, local LCs, and so on and so forth. Who can give an answer?
That's not an easy question to answer in terms of I haven't actually calculated or made an estimate of the overall cost. I mean, it's obviously going to run into millions of dollars given the nature of the case and the duration of it. And the issues that are likely to arise, and there's not only just the trial process, but it's also ancillary issues and matters that are likely to come up. And that's why it's a little bit hard for me to give you a figure. I can give you a general estimate, and all I can say is that it's going to be costly. But at the same time, I can't avoid this cost. I can't avoid not employing counsel to conduct this case from overseas. I generally find that counsel overseas, the cost that we incur with respect to them is fairly reasonable in terms of comparison with the cost that you've got to pay with counsel here. And having a Queen's Counsel or a senior counsel is not cheap. The fees that they charge on a daily basis can range from $40,000 to $80,000 a day, to give you an idea. And so that the involvement of counsel, that is members of the private bar, is a costly exercise, and costly for both sides, I may add. And so it is going to cost us a fair bit of money. But we need to have the counsel involved. And to be able to conduct the case properly.
Well, Chairman, of course we know it's going to be costly. So my first question, which the DPP did not answer, is why you estimate it would take 5 years? Because even the Citizens Radio case, us just taking part in the broadcast, that thing dragged on for more than 4 years. And also, my question is, are you going to spend more money, which you are going to do, to spend more money, whether it's going to hire overseas QC or others? We want to know the amount. You have to give, Chairman, I think the administration should give the Legislative Council an accurate picture of how much. I mean, at this stage, it may not be able to, but at least you have to give us a reasonable estimate of how much it's going to cost the taxpayers. And if you can't do it, I hope you will do it before you go to Finance Committee.
I wasn't expecting you wanted this before the meeting, otherwise we'd sit down and we'd do some sort of calculation for you. But I'm quite happy to provide that to you after the meeting. But I'd like to do it properly by way of consideration. As I said, it is to some extent a fluid situation. It depends on exactly how things develop. I mean, I don't know exactly what sort of response I'm going to get from the defence in relation to the current proceedings. There's committal proceedings. We don't know if there's going to be a preliminary inquiry. All these issues that we've got to wait and see what happens will impact on the cost. As to the 5 years, we've given that an estimate. If we need more time, we'll come back to you. I appreciate the point you make, but we thought we'd be reasonable, ask for 5 years, or a little less than 5 years, and if we need more time, we'll come back to you on that.
Chairman, my question is, if you're going to hire outside lawyers, whether it's local or overseas, will you need to come to the Finance Committee to get extra funding?
No, that's within our vote, and we won't need to. We don't normally come to you for that purpose.
Well, that's why we need to know the information now that you are before us. So I hope the administration will provide some more information. I mean, the Deputy Secretary is going to speak, but I hope they'll provide more information for us as much as possible at this stage so that we can have a good grasp of how expensive this case is going to be. Thank you, Chairman.
I believe they will support us with the information after the meeting, but there will still be an estimate. Yes, I understand. Yeah, please, give us the relevant information after the meeting. The Deputy Secretary would like to speak, Chairman. Just one supplement. The ESC is asked to consider the creation of this five-year post. We're talking about for the 2012-2013 post and the posts that need to be created. So the budget for 2012-2013, we need to add this post and also the resource consideration. So after the ESC approves the proposal, then we will next go to the FC and ask the FC for the resources required for the creation of this post to be put into our 2012-2013 budget. The information sought by Ms. Emily Lau, the Prosecution General, already told members that for other resources not related to this case, that is, in respect of dealing with such cases, what resources will be reserved for those, that will be supplementary information. For the next financial year, if what resources will be required in dealing with this case, it will be reflected in the budget for the next year. For the second round, we have two members, Mr. Kenneth Leung and Mr. Martin Liao. Mr. Leung, thank you. I'd like to ask this question. When you consider recruiting external support, you can hire local SCs or overseas QCs. My worry is that in this case, the defendant have lots of ammunition. They may hire many QCs from overseas. This is a very important case, and my worry is that if you don't have a criterion as to how you're going to, whether you're going to hire overseas QC or local SCs, whether it's the former or the latter, you may be, missing. They may be missing an opportunity to participate in this important case. So, in making your decision to engage QCs from abroad or SCs locally, what criteria will you adopt?
Approached and spoken to counsel here in Hong Kong and who are involved in the case. So we have a local senior counsel as well as overseas counsel. So basically they're already been approached by the Prosecutions Division and are available to prosecute our case for us. In terms of criteria, I go to the best available, and from my own professional experience and assessment of them, people who have an established, proven track record in this area, that are going to be the right sort of person to deal with the case, As you will have read in the papers today, yesterday we secured the admission of Mr David Perry, Queen's Counsel, who's regarded as one of the best criminal law advocates in the United Kingdom, and who has already conducted cases here in Hong Kong, so he's quite experienced with the Hong Kong jurisdiction as well, so we have that added advantage. I've also approached and I have brought into the team other counsel with highly recognised skills in corruption and white-collar crime cases, and the other counsel that and local counsel. We have actually a junior counsel currently also employed, working and assisting in the case as we speak, who's recognised as one of the best junior counsel for preparation of white-collar crime cases. So I've made sure that we've got a good team of people together, and that they can work well together. That's a well-coordinated team, and that they'll be able to carry out their responsibilities. I must stress this, that it's my objective. My objective is to make sure that this case is properly prepared and presented, and done so in a fair and efficient manner. And I want to make sure that that the case will be presented on that basis, and that we do all the necessary preparation. No stone will be unturned. We'll make sure that we do our job properly. And so you'll have to rely to some extent on my professional experience and judgment in bringing together the right people, and I believe that that's what we're doing or have done.
Okay. 下一位係廖長江議員。
Mr. Martin Liao.
Case-specific position. And I was wondering, there are two questions associated with this. The first is whether you have considered open recruitment to fill this position. And the other question is whether it is usual for the DOJ not to employ open recruitment to fill this position. Thank you.
I'm not adverse to the notion of open recruitment, but we have to move. With this particular case, we've got to move fairly quickly. We have to do our job, and there's no time to really go through the process of open recruitment. As you can appreciate, it takes time. But there's another reason why open recruitment wouldn't have been applicable and wouldn't have been appropriate here, is that we needed somebody that's already got the proven skills and experience of prosecuting. And that's not something that's readily available outside. And also dealing with the administration, dealing with the way the office operates and works in making requisitions for assistance, and dealing with the bureaucracy generally, this is part of it. This is not usual. It's not somebody from outside, from the private bar, would not have this sort of experience being brought before LegCo and being made to account, or having to fill in a multiplicity of papers to make a requisition, etc., and know how government works. So we've got that side of things. So we needed somebody not only as a first-class lawyer, good lawyer, but also somebody that is experienced with the way things work within a government department. The other point that you make about it being unusual, we sometimes do have open recruitment. It doesn't happen that often, but we sometimes do. We generally recruit at a base level, at the very entry level at Government Council, and then we train them up. I mean, we have now, I can say, I know I'm digressing, but we have extensive training program. I'm making sure that the council are being given the appropriate exposure and training to be first-class prosecutors, and I'm putting great emphasis on that. So to some extent, you need to come in to be able to be then developed into a good prosecutor, because it's a different set of rules and approach to conducting a case.
何專員有補充？
就係喺呢個情況咧，呢個職。
Well, this is a civil service post. According to the civil service rules, if a suitable candidate exists internally, then we will give priority for that internal candidate. Unless we found that there is no suitable internal candidate, then we will go for open recruitment. We have So we are now complying with the civil service regulations this time. Dr. K.K. Kok.
About this mega case, we would like the government have adequate resources and the expertise to handle the case. Now, regarding on the document provided on the section 9, apart from this DPGC, you have a VA counsel and also a senior government counsel. So the team is only made up of 3 counsel altogether. Of course, you need to hire a lot of outside senior counsel and counsel. My question is, now we would very much like to have a very rational use of resources. If we have sufficient manpower, not only the DPGC, of course we have some senior counsel and counsel all together in the team. Would it be possible to lower the total cost of like hiring the outside senior counsel or counsel? That would cost a lot of money now. And of course, we can't judge for you, but we would like to make sure that adequate manpower will be provided in the whole course. We are very much concerned about we cannot predict the outcome, but we would like to see the government is all the available resources being provided to make sure that the case is being duly conducted. So as there was doubt as to the experience, expertise, and also the numbers of manpower being allocated to these particular cases, would there be any implication of further resources which will be needed in a due course?
I mean, this is obviously something that I have in particular, because I personally are involved in the case. I've had to sit down and consider very carefully, and as I said, from my experience and knowledge of cases of this type. I mean, it's very hard to put a price on justice, actually. And in these sorts of circumstances, you just have to pay the price that justice requires in the circumstances. And I will make sure that if there's any need for additional resources that I require by coming here before this committee, I'll come back before you if there's the need. At the moment, from the assessment of the case and what we actually need, we've explained it. We need a dedicated team, and so we need the additional D2 position. With regards to the employment of outside counsel, as I've tried to indicate, there are already quite a few counsel involved in the case, and they're not, they'll be called upon when required and when needed, and as part of a coordinated team effort in order to prosecute the case. And whatever is required to ensure that this case is properly prepared and presented and done fairly, I will employ the necessary resources and staff to ensure that that objective is met. I can assure you of that.
Okay.
If members have no further questions, I will now put the item to the vote. For all those members who are in favor of EC 2012-13-10, please put up the hands. Those against? I believe all members present, the majority of members present are in support of the paper, so the paper is therefore approved. Finally, I'd like to ask members, that is in relation to the items discussed today, do we need to have the 2 items voted upon separately at the FC meeting? Chairman, I think it is our usual custom that they should be voted on separately because they involve the creation of 2 separate posts by 2 different departments. Well, that may not always be the case. What the chairman is saying is that where the FC discussed these 2 applications, whether or not they should be discussed individually again. Chairman, some colleagues, I think you saw that members actually lumped the discussion of the 2 papers together. So I don't think there's any problem. We will to combine the discussion on the creation of both posts together. The question is whether the voting should take place separately. Thank you, Dr. Kok. The usual practice is that should there be any ESC project which we need to go to the FC after members have debated. And if members think that the proposal is not controversial, then the first item on the FC meeting, of course, there might be outstanding items from the previous meeting, but there are, standing items which would be the proposal from recommendation of the ESC, and there could be several items. Today, for example, there are 2. If there are no special requests, then we will ask whether members support the proposals which are already supported by the ESC. There will only then be one vote.
喺財委會度再經過討論，去為嗰個特別嘅議題咧，再嚟一個討論同埋表決。剛才主席問大家，其實就話覺得有冇需要，如果冇需要就未必需要咁做。
即係主席唔好意思，即係我梗係希望佢哋盡早去攞到呢個撥款啦。咁大家都睇到重要，不過我就唔係好清楚咧，我亦都唔敢包咧，就到時有冇委員。
I hope that they can get the funding as soon as possible. But then some FC members are not members of the ESC, and they may have questions to ask. And I think to err on the safe side, we should invite the ICAC and the DOJ to attend the meeting. I believe they will come. I believe they will be present at the FC meeting. Because we have 2 different departments, ICAC and DOJ, and that's why we have 2 separate papers, 2 separate items. But in fact, we're talking about one case. The 2 posts are for one case, and so I want to ask members whether the 2 can be dealt with jointly at the FC, merely for efficiency's sake. All right, so. I think I will recommend to the FC that these will be discussed or dealt with jointly, the 2 items. Yes, the clerk to the FC. Yes, Chairman. Now, concerning the recommendations of the ESC and the recommendations of the PWSC, usually these are not discussed again by the FC. But then if it is members request that officials concerned be invited to the FC meeting to answer questions on a particular PWSC or a particular ESC item, of course we will make the arrangements. And then some members may want some supplementary information from officials at the FC meeting, but then at the FC meeting the officials are present, but then those members may not be present. And in fact, the officials might have discussed those issues with members before the FC. And so now, if members can give us notice 2 days before the FC meeting, then we can invite the officials concerned to attend the FC meeting. Now, in fact, Ms. Emily Lau did ask for supplementary information. But of course, the Deputy Secretary for the Treasury told us that if extra funding was needed by the DOJ, that would be handled by the next exercise of the draft estimates. And so I think, Chairman, to err on the prudent side, I think we should ask members whether they want to ask the officials questions at the FC meeting. Now, as the chairman, Mr. Kwok, I cannot really take care of members who are absent or who have left early. Now, it's the responsibility of members to attend meetings, to sit through meetings, but of course it's their freedom to leave before the ending time. So I'll just be taking care of views of members present. Now, not just Ms. Lau, I would also want to know more about the estimated total cost for hiring QCs and SCs, and I hope that he can give us the information before the FC meeting. Now, in fact, we totally support the funding applications. So we hope that Mr. Servos can give us the information before the FC meeting. That would help to speed up our work. I want to know when these ESC items will go to FC. The 30th? When? Chairman. The recommendations of the ESC will go to FC on the 30th of November. So we've covered all the items on the agenda. Thank you very much. Meeting adjourned.